on a preliminary hearing. Does your client still wish to do that today?
Yes, that is correct.
All right, Mr. Sommerfeld, are you prepared to go forward with that today?
Yes, I just have a question on has Barnett Hodges, has that been removed from the docket today?
No, we just took things out of order a little bit. That'll be the next case that I call. I've got that and the Ruiz matter still pending today.
All right. Yeah, the department is ready. I'd like to call Ann Sullivan, please.
Before we go any further, let's pause right here, because what you're about to hear is not a trial, it's a probable cause hearing, and that distinction matters. At the center of this case is a violent allegation against a father, a mother with a long CPS history, and a teenage child caught between two unsafe options. The question isn't who's innocent, it's who, if anyone, is safe right now. And the answers get uncomfortable fast.
Before he calls the witness, I just want to explain to Tessa, we discussed this is not the trial, but this is a probable cause hearing. So just in case you thought what happened, but okay, she understands. Very good, thank you.
All right. Ms. Sullivan, I'd like to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead and put your hand down. Mr. Sommerfeld, you're a witness.
Thank you. Ms. Sullivan, can you state your name, please, and spell your last name?
Ann Sullivan, Sullivan.
And how are you employed?
I am a CPS investigator with Otsego County Department of Health and Human Services.
And did you have an investigation with the children, Kai and Layla Patton?
I did.
And who is the mother of Layla?
Tessa Patsy.
And so, but she's not the mother of Kai.
Correct.
All right. And is she present here today? Do you recognize her?
She is.
Okay. Tell us, there was something that happened in Otsego County that you investigated, and that incident affected respondent mother. Can you first tell us about what you were investigating in Otsego County regarding the children and the father, Ricky Patton?
Yes. On November 14th of 2025, I had received a complaint regarding a physical injury against Layla. The perpetrator was identified as her father, Ricky Patton. I made face-to-face and interviewed the children. Subsequently, on November 17th, that was on a Friday, that following Monday, I did file a petition to remove the children from Ricky's care. At that time, we did look at placement with Tessa. However, per DHS policy, placement needed to be approved by the local director before placement could be made with her. It was determined on or about November 20th that placement was not approved by local director, so therefore a petition had to be filed against Tessa removing Layla from her care in order to afford her her rights as a parent that we were not placing with.
Okay, can you tell us a little bit more? You just said it was an incident with the father involving one of the children. Can you be a little more specific and why that turned out to be a removal of the children?
Yes. It would have been the hours of the early morning on November 14th. Ricky had assaulted Layla. Police were at the home due to previous events in the evening. The children were in the basement. And when I say the children, I'm referring to Layla, her brother Kai, and then another child that resides in the home, Cameron. All three children reported that Layla and Ricky had a verbal altercation, and then Ricky had slammed Layla onto the floor a couple of times, and he had put his left forearm to Cameron ran upstairs and alerted police, and subsequently, Ricky was arrested for that incident.
Okay, and so
This is the moment where the entire case pivots. The father, who had full custody, is accused of violently assaulting his own child in front of other children, leading to an arrest. Once that happens, CPS is legally required to reassess every possible placement option, including a parent who wasn't even present. And here's the key point. The mother isn't being accused of causing this incident. She's being evaluated because the system suddenly has nowhere else to turn. So ask yourself, when the custodial parent collapses overnight, how far back does the court get to look?
since it resulted in a removal petition, we had to look at placement of mom with Tessa, but she lived somewhere else and she was not at that incident.
Correct. She resides in Genesee County.
Okay, and the petition alleges that there was significant CPS history, and I heard you explain that we needed a special approval per department policy to place with mom. Was the significant CPS history, was that a factor that was presented to the director for a decision based on placement?
Yes, it was.
And so can you tell us what are some of the specifics, and tell me, I could be speaking out of turn here, but was this history, is it still in a state of being unresolved, or would have been a barrier to getting the children, having the child stay with her?
So essentially, Layla was removed from Tessa's care in 2011 due to substance use. And then she was also, at that time that Layla was removed, she was charged criminally with charges. As recently as 2024, I believe it was July of 2024, there was a CPS investigation which resulted in an ongoing case. There was a substantiation. Was involved in that investigation and ongoing case, and Tessa had tested positive for as recently as January of 2025. And then during that ongoing case, ultimately they did close that case because Tessa was refusing drug screens. She had blocked the worker's number and was refusing to participate in services that were being offered to her during that ongoing case.
Okay, and then your petition talks about when Tessa was placed with her mom, she was out of school for a significant amount of time. Can you tell us about that?
Yes. As of right now, Layla is enrolled in school as a freshman. She should be at a junior level. It was reported by Layla as well as the previous CPS worker in Genesee County that Layla had not attended school and was not enrolled in an online program for approximately 2 school years.
Okay, and the father of Layla, Ricky Patton, he was granted custody of Layla in 2025, June of 2025?
Yes, he had filed a motion with the court requesting custody of Layla. About the time, it was just after the ongoing CPS case had closed. He was granted full custody of Layla.
All right. And so was she awarded parenting time of Layla?
She was awarded parenting time visits every other weekend.
Okay. Did she take advantage of that? Did she have parenting time?
She had her first parenting time at the time that the court granted the custody to Ricky. She kept her that weekend, and then Layla went to Ricky's care. And then it was reported that she did not exercise parenting time until it was either late October or early November of 2025. So she had gone approximately 3 or 4 months without exercising that parenting time.
Okay, and that's we're talking about June to October or November of 2025.
Correct. Well, sure. Her last parenting time was, I believe it was the first weekend of July. So it would have been from July until October or November. Correct.
All right. And did she express, well, first of all, how old is Layla?
Layla is 16.
And did she express one way or the other about going to live with her mother?
She did. Layla expressed to me that living with her mother was very traumatic for her. She was often left alone and caring for her twin siblings, who I believe are 9. She reported that if she were to be placed with her mother, she would run away.
Okay, and based upon all of that information, the director decided that placement would not be appropriate at this time.
Correct.
And so then the department had to file an amended petition, also making mom a respondent.
Yes.
Okay. And so at this time, the department takes the position that mom, respondent mother here, her home is unfit due to neglect or unmet needs that would make, put the child at a risk of harm.
Correct.
Okay. And then your petition also alleges that, in addition to the child expressing the desire to run away if placed with mom, that she suffered significant trauma. Do you think that there could be a substantial risk of mental harm to the child if she were to be placed with Tessa at this time?
Based on what Layla has expressed to me, she wouldn't go into a lot of detail about the trauma, but I would say I would agree with that statement. Yes.
Okay. All right. Thank you, Judge. I have nothing further.
All right, Mr. Mr. Delaney, do you have cross-examination questions?
Yes. With respect to the father, is it true that he's entered a guilty plea to some type of assault involving Layla?
I am not familiar with where he's at in his criminal case, so I don't know the answer to that.
All right. Is he at the county jail, the SEO County Jail at this time?
He is.
Okay. On these pending charges?
Correct.
Okay. The assault or the alleged assault by Ricky Patton on his daughter Layla, you became aware of that on or about November 14th of 2025, is that correct?
Correct.
Okay. Prior to that time, everything that you testified to regarding the mother, the department already had knowledge of, is that correct?
That is correct.
However, none of those allegations that were known to the department about Tessa before the incident involving Ricky Patton, before November 14th, didn't warrant the department filing a petition at that time. Is that correct?
That is correct.
Okay. If it didn't warrant a petition before November 14th, why does it warrant a petition now?
Essentially, because the department did file the petition against Ricky following that incident and removed from Ricky's care, and Ricky had full custody of Layla at that time. So essentially with that removal occurring, we had to assess placement with Tessa per DHS policy.
Has anyone at the department inspected the home of Tessa on or after November 14th?
Yes, Genesee County DHS worker went to the home.
Okay. Do you know when that was?
I don't remember the exact date off the top of my head, but it was right. It might have been on November 17th because as soon as I filed that petition removing Layla from Ricky's care, we started the process in considering placement with Tessa. So it might have been on the 17th. It was in between the 17th and the 20th. I can tell you that.
Did the Genesee worker find that the home, based on the after November 14th inspection, was unfit for Layla?
They reported that the home was clean and appropriate, and that Tessa was residing with was at that time residing with her mother, and that the home itself was appropriate placement.
With respect to the father, it's probably going to be some time before the department even considers returning Layla to his care.
It essentially, I mean, based on the last hearing, Layla might not return to his care.
Okay. So the department would have to consider placing the child with the mother, but at least at the moment, the home is appropriate of the mother.
The home is, yes.
This is where things get legally tricky and emotionally charged. On one hand, CPS admits the mother's home is clean, appropriate, and stable on paper. On the other hand, they're saying the risk isn't the house, it's her unresolved history, substance use, prior CPS involvement, missed schooling, and a child who says living there was traumatic. So here's the real tension. Should a parent lose placement based on past behavior when the present looks stable? Or does the child's fear outweigh everything else? Drop your thoughts in the comments. This is where reasonable people sharply disagree.
The criminal and substance abuse charges go back all the way to 2011. Is that correct?
That is correct.
Okay, so that's 15 years ago?
Yes.
Okay. All right, I have no further questions, Your Honor.
All right, thank you. Any follow-up, Mr. Sommerfeld?
I don't. I'd like to see if Ms. Hansel has any question.
We'll go there next. Ms. Hansel, any questions as the guardian ad litem?
Yes. To the best of your knowledge, is Tessa, the mother, is she receiving any services right now for drugs, or is she in any type of a program that would assist her with addiction?
To my knowledge, not that I'm aware of.
Okay. Well, are visits taking place right now between Tessa and Layla?
I did speak to the foster care worker prior to this hearing, and she did confirm that Tessa is participating in weekly supervised parenting time.
Okay. And how has that been going?
She did not report any concerns at this time regarding visits.
Okay.
They've been appropriate.
All right. So, if I understand correctly, it's not the condition of the home that concerns you. It is the unaddressed addiction issues with the mother that are concerning to you. Is that correct?
Correct.
Okay. And so you are seeking a plea from the mother, and so that she may engage in, so that it can be ordered that she engage in services that would be crucial for having Layla return to her. Is that right?
Yeah, we would ask that she participate in services prior to having Layla placed in her care.
Okay. Do you have any reason to believe at all that at this point in time that the mother Tessa has ceased use of or other illegal drugs?
From my understanding, my conversations with Layla, Layla has expressed that she does believe that her mother is not using substances right now. However, Layla has expressed to me that with Tessa living with Layla's grandmother, that has helped that situation.
Mm-hmm.
And Layla has expressed that essentially the way she worded it is things are good now, but she doesn't know how long things are going to be good.
Okay.
If that makes sense.
Okay. So this living with the grandmother is not a permanent solution. That's not something that the grandmother and Tessa are saying is permanent, that will continue throughout the duration of raising these children. Is that right?
I have not had that conversation with either one of them, so I don't know if it's temporary or permanent at this time.
Okay. Where are the younger, the twins?
The twins did remain with Tessa.
Okay. Okay. And to the best of your knowledge, is there any type of an open case right now in Genesee County involving Tessa?
So the foster care worker here has been working with Genesee County to have a worker assigned to Tessa down there.
Okay.
There's not an actual, there's the open foster care case, but there's not an open CPS case, if that makes sense.
Okay. So the open foster care case, are the twins considered, are they in foster care, or are they under any type of guardianship with the grandmother? Is her presence required to keep that?
So the twins are not part of the petition at all.
Right.
So they're not in foster care.
Okay.
So essentially they could receive services through the foster care case if the court takes jurisdiction of Tessa over Tessa. In Tessa's portion of this, I shouldn't say over Tessa, but in Tessa's portion of this, then they would not necessarily be part of the foster care case, but they would be involved with a foster care case.
Okay. Let me back up a little bit. And I don't mean to make this too murky here, but is it possible then that the twins' father may have, does he have some type of custody of them? And are they, like in this case, could it be that that Tessa has standard parenting time, or is she not the custodial parent of the twins, or do you know?
I don't know what the custody arrangement is, but it is my understanding that Tessa is the custodial parent of the twins.
Okay. And who told you that?
That came from, I believe Tessa and I had talked about the twins, and then from the worker in Genesee County that did the home assessment, they said that the twins were living with her full time.
Okay. Okay.
Ms. Hansel, can I direct you back to this case? I appreciate your need to know on some of the twins information, but let me focus on where we're at with this particular case, which has only to do with Layla.
And I appreciate that, Your Honor. I was just trying to figure out what was going on.
Yep.
Okay, I have no other questions at this point. Thank you.
Thank you. Mr. Sommerfeld, any additional witnesses or evidence on the probable cause determination?
No, thank you, Judge.
Mr. Delaney, any witnesses or evidence to produce as to the probable cause?
I had a follow-up question for Ms. Sullivan based on Ms. Hansel's questions.
Go right ahead, sir.
There's a, and I think we touched on this briefly. There's an existing custody order between Tessa and Ricky with the Otsego County friend of the court. Is that correct?
That is correct.
And I believe, and I've not seen that order, I wasn't involved in the case, that under the order, Ricky has custody of Layla. Is that correct?
That is correct. He has full custody, full
So-
physical custody.
Okay, so Tessa would still need to, irrespective of this case, go to the friend of the court to get that changed to get custody of Layla.
Correct.
All right. Is there parenting time in that order for Tessa?
She's ordered parenting time every other weekend.
Okay. Thank you.
All right. Ms. Hansel, any witnesses or evidence as to this probable cause determination with Ms. Tessa Pesci?
No, sir.
All right. Mr. Sommerfeld, any arguments?
Judge, Miss Sullivan has stated that there was an incident involving the father in Otsego County where the children were domiciled, that son, Kai and Layla. And while this one really more focuses just on Layla, that incident resulted in a removal. We had to look in to see if mom was appropriate. She was not part of that incident. She was in a different location, part of the state. So Ms. Sullivan testified that there was prior drug use. There's things we don't know. And because of that, I believe that the home would be unfit due to, at this point, really neglect, unidentified barriers. Maybe things are better right now. We just don't know those things. And the last investigation that Ms. Sullivan testified about was that mom didn't cooperate with that and in fact was testing positive. So, you know, we put it through this process, running it through department policy, and the department could not in good conscience place the child there. And so Ms. Sullivan testified that there could be a substantial risk of mental harm. That's MCL 712A.2B1. That's another part of the statute here. She said Layla suffered substantial risk or mental harm in the past. We've heard statements that her mom can parent at times, but then there's this issue of maintenance that doesn't seem to be consistent with the long-term needs of a child. I would think based on both of the statutes, Judge, they're met one way or the other at the level of probable cause here, and I would ask the court to authorize the petition as it relates to respondent mother. Thank you.
Mr. Delaney.
This case is not a case of policy, but a question of law. If you look at the petition in this case, the second page, number 4, there are only 2 boxes that are checked. And I certainly have had cases where a father who is not the custodial parent has never seen a child since it was born, and the child is 5 years old, but the mother gets involved in some activity, let's just say drug use. And the father takes the position that, look, I'm in California. I know I haven't seen this kid in 5 years, but I've never abused this child. Why am I being brought into this? That would trigger one of those boxes in that case. And I've had cases that have been like that. And so it's proper care and custody. True, you haven't impacted this child and DHS has stayed out of your life, But now that the mother has an issue, who's the custodial parent, they're now looking at you. But those aren't the facts here. Prior to November 14th, the mother was not petition worthy at all. And now the mother is petition worthy, and they're general allegations. Let's look at the first box that's checked. The parent or other parent legally responsible for the care and maintenance of the child has neglected or refused to provide proper care and custody. That's not the case here. And it continues medical, surgical, morals, and has subjected the child to a substantial risk of harm. And that's as of November 14th of 2025. We can't have petitions that cover an entire person's lifetime and say 15 years ago, 16 years ago, a month ago, 2 months ago. It's very speculative, even at a probable cause hearing. The second box that's checked is that the home or environment, and the court knows the list, neglect, cruelty, drunkenness, is an unfit place for the children to be.
I believe that those allegations fit the requirements of the allegations made in the amended petition, which include the parent or other person legally responsible for care and maintenance, when able to do so, neglects or refuses proper or necessary educational or other care necessary for the child's health or morals, or subjects the child to a substantial risk of harm to her mental well-being, and also that the home or the environment, by reason of neglect, is an unfit place for the child to live. The testimony in this case indicates that there was an unfit home environment, and I differentiate between the physical findings of the home being fit and the care and necessary for a child within the home being fit. There was within the home for a long period of time. 2011 it began, was ongoing as of 2024 and into 2025. So there was long and difficult substance abuse history there, charges and ongoing CPS cases for lengthy periods of time, which lead the court to believe that would be an unfit place for the child to live in. There was also allegations of unfit home environment due to educational neglect. The child actually missing 2 full school years. She should have been a junior in school and now is a freshman in school. And so there would be educational neglect, which would make the home an unfit place for the child to live, and also not provide proper necessary educational care and lead to a substantial risk of harm for mental well-being. And finally, there was the trauma that Layla indicated to the Department of Health and Human Services that she had while living with mom, indicating that there was a substantial risk of harm to her mental well-being, and that the home environment due to neglect was an unfit place for the child to live in, indicating directly from the child. So for all of those reasons, I do believe that there's proper probable cause. Mr. Delaney has argued that the mother was not petition worthy and that therefore there's no factual basis for the court to order that in this case. I would simply note that I disagree with that assessment. The fact that there was no petition doesn't mean that the facts didn't rise to the level of meriting a petition. And it was done once the child was removed from the father, and then it was assessed. So I better late than never, quite frankly. But again, the fact that they didn't do it doesn't remove the facts that I've indicated on the record, dealing with use, the failure to put in school, and the trauma to the child. And so for all those reasons, I do find that there was proper probable cause.
In the end, the judge sides with caution over hope. The court finds probable cause, not because the mother caused the father's violence, but because of long-standing concerns about educational neglect, substance abuse history, and the child's own statements about trauma and fear. This ruling doesn't terminate rights, and it doesn't decide custody forever. It simply opens the door for court-ordered services and oversight. And if you found this case as complex and unsettling as we did, hit that like button, share your thoughts below, and subscribe for more clear, no-nonsense courtroom breakdowns that go beyond the headlines.
For the petition, and I will authorize the petition at this time based on that finding.